Hello, everybody, and welcome. So, we are going to go over the latest filings in both the Bryan Kohberger case and the Chad Daybell case. There's a little bit more in the Kohberger case than there is the Chad Daybell case, so we'll do the Kohberger one first. If you haven't subscribed, please hit that subscribe button, hit the notification bell so you're made aware when we go live and we do updated reads and court documents, etc. Please give this video a like. It's much appreciated. So tomorrow we will be having our live draw right here at 11:30 a.m. Eastern for those of you who have either done a super chat of $10 or more or have done a super thanks. There's a little heart below each video where you can do a super thanks. Any US $10 super chat of $10 or more gets you an entry into that draw, and it is going to be held tomorrow morning right here live. So you'll be able to see the winner and everything and chit chat with us a bit before we have the draw. Okay, so let's jump right into this, you guys. Okay, so here is the first document. Since the last court hearing that we've seen in the Bryan Kohberger case. So Ann Taylor has filed a motion to change venue. A lot of you have probably heard about this already, but we're just going to go over it and see how the prosecution has responded. And then there's other documents that have come forward, and there's going to be an argument about them also. There's going to be another hearing in the Bryan Kohberger case, and it is scheduled for the 28th of February, 4 p.m. Eastern time. And I am almost positive they will be discussing all these issues that have come up since the last hearing. Now, the judge, this is some motions that the defense has filed. The judge has also given his order regarding appealing his decision. We'll get to that. I think it's a couple filings here down the line, but let's get into this and get through these as quickly as we can. I'll skip through a lot of parts that are just repetitive and stuff like that, you guys, so we're not just seeing things repeated over and over. We'll get the gist of what's going on and why. So Bryan Kohberger, by and through his attorneys, and hereby moves this court for a change of venue. By this motion, Bryan requests a jury pool from outside Latah County. The motion is made pursuant to the 5th, 6th, 8th, and 14th Amendments to the U.S. Constitution and 18 of the Idaho State Constitution, ICR Rules 21, etc. She says, a fair and impartial jury cannot be found in Latah County. I don't know how they say this right off the bat because I haven't seen them produce anything like they've done. I know in a lot of other cases, they go out and they do questioning of people and surveys and stuff like this to see and give some indication whether they could get a fair jury pool. I haven't seen any of that being done, and that usually is a requisition and required before requesting a change of venue. But they haven't done all that. All they've got to go by, all the judge has to go by is Ann Taylor's word at this point because she's got no documentation to back this up. That's just my opinion. Okay, so a fair and impartial jury cannot be found in Latah County owing to the extensive inflammatory pretrial publicity allegations made about Mr. Kohberger to the public by media that will be inadmissible at this trial. The small size of the community, the salacious nature of the alleged crimes, and the severity of the charges Mr. Kohberger faces. Well, I'm in Canada, and I've heard everything about this case. So I don't think that they're going to get anywhere where people have not heard about this case. Enlarging the jury pool will not do anything to overcome that persuasive prejudicial publicity because the Latah County does not have a large enough population center to avoid bias in the community. Well, there's bias across this world regarding this case. So I really don't think even moving this 50 miles away, 100 miles away, 200 miles away is going to make any difference. Further, the size of the community and the interconnectedness of its citizenry is problematic and will prevent a fair and impartial pool of potential jurors. Well, that's why you have one year, right? Mr. Kohberger, by and through his counsel, requests an opportunity to be heard, evidentiary presentation, and argument no sooner than the end of April. Well, why wouldn't you want this right away, right? Why are you saying the end of April? This was filed the end of January. So you want 3 months for this to drag out. So they're trying to drag this out for a trial date also, because if there's still hearings and motions and whatnot to be heard, then they can't start the trial. And we know that the prosecution wants to go to trial this summer, right? So this was filed January 30th. So each time that their motions are denied, they come up with something else for a delay. Instead of, like she's been saying, we've got so much evidence to go over and so much paperwork and so much, blah, 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 blah. We don't have time. Well, instead of doing stuff like this, where you don't even have information to back up what you're saying, why would you be filing these motions? This is taking time away from doing what you should be doing to prepare for trial, in my opinion. Okay? Now, if she had filed this with evidence of surveys and questionnaires and stuff like that they've gone out into the community and they've done interviews and stuff like that with people, and look at Judge, we can't get anybody to say that they could be fair and impartial. I get it. Then I would get it. But she has given nothing to back this up. So the next document that came out was the order denying, and we'll get back to this motion to change venue because the prosecution does respond to this, but I'm going in order that the documents came out, okay, in the file. So before the prosecution responds to this order from the judge came out. And this is an order defying the defense motion to reconsider and motion for permissive appeal, which means the judge would have had to disagree with his decision that he already made regarding this motion, the last motion and he denied it. So they wanted permission to go ahead and appeal his decision. He's not going to change his mind. He's not going to say he made a mistake on his last ruling. Okay. So they give the background here. I'll scroll through this slowly. So if you guys want to pause it and read it, you can. But they're saying that the defendant filed a motion to dismiss the indictment on grounds of error in grand jury instructions, or in the alternative, a remand for a preliminary hearing. So they wanted the grand jury indictment thrown out. They wanted a preliminary hearing. And then they say on August 23rd, 2023, the defendant filed a motion to dismiss the indictment on grounds of a biased jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct withholding exculpatory evidence. Now, there was hearings held on both of these. There was orders that were made. The court made an order denying the motion to dismiss the indictment for inaccurate instructions to the grand jury, and a sealed order denying motions to dismiss the indictment based on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. And that was done on December 21st, the defendant filed a motion to reconsider the orders denying the motions to dismiss the indictment, and or in the alternative for permission to appeal the interlocutory orders and a stay of proceedings. That's what the judge is ruling on right now. So they're talking about the two-part hearing. This is the last hearing that we seen. The morning part we couldn't hear, but we did listen in on the afternoon session. So they're going through this and explaining what happened that day. Then the judge gives the law on this, saying that the Idaho rules do not expressly provide a motion for reconsideration like Idaho rules of civil procedure. There is no criminal procedure rule that provides a basis to reconsider a decision of this kind. The Idaho rules of criminal procedure have nothing similar to the Idaho rule of civil procedure. However, such motions have not been deemed improper if made under the Idaho rules of civil procedure. So, I mean, there are two different kinds of cases. This is a criminal case, there's civil cases, there's all kinds of family cases, there are all kinds of different cases, right? To obtain permission to appeal an interlocutory order, the appealing party must first seek permission from both the trial court and that issued the interlocutory order and the appellate court before the appeal can be heard. Even if the trial court enters an order disapproving a motion for permission to appeal, the appellate court may still accept the appeal. Under IAR 12, an appeal must be taken from an interlocutory order under very limited circumstances. The first order appealed must involve a controlling question of law, which is there is a substantial grounds for a difference of opinion. Second, it must appear that an immediate appeal from the order may materially advance the order's resolution of the litigation. It was the intent of IR 12 to provide an immediate appeal from an interlocutory order if substantial legal issues of great public interest or legal questions of first impression are involved. In addition to the factors set forth in IR 12, a court determining whether to hear the interlocutory appeal should also consider the impact of an immediate appeal upon the parties, the effect of the delay of the proceedings in the district court pending the appeal, the likelihood of or possibility of a second appeal after judgment is finally entered by the district court and the case workload of the appellate courts. Which is just adding more and more and more and more and more when you should be preparing for trial instead of filing all these motions that you know are going to be denied. So he gives his reasons why he's denying this. And he says the court does not find error with any factual findings or application of well-settled law to the facts as found. In reaching its decision, the court spent a significant amount of time reviewing the grand jury proceedings and researching the issues presented by the defendant. Reconsideration does not change this court's decision. For the reasons articulated on the record on January 26, 2024, the defendant's motion for permission to appeal from interlocutory orders is denied. First, neither the order denying the motion to dismiss indictment for inaccurate instructions to grand jury or sealing, order denying motion to dismiss the indictment on grounds. Okay, I'm not reading through them all again. Indeed, it is well settled in law, Idaho. It is well settled law in Idaho that the standard for grand jury indictment is probable cause. They're still fighting this, you guys. It's not beyond all reasonable doubt. It is probable cause, not beyond a reasonable doubt. Defendant himself recognizes that the whole of modern jurisprudence on the issue is against his novel theory, and they're saying, so this is why I believe, you guys, that it is Bryan Kohberger that keeps bringing up, well, let's go for this, like all the 1800 law and all this, because this sentence right here, the defendant himself recognizes that the whole of modern jurisprudence on this issue is against his novel theory that beyond a reasonable doubt is the applicable standard. In Idaho, colleagues of the defense counsel have presented this theory to at least 3 district judges, and all have agreed that probable cause is not beyond a reasonable doubt is the appropriate standard. Thus, there are not substantial grounds for differences of opinion on this issue. Okay, and it goes on to state other Idaho criminal laws or criminal rules. Although the defendant argues this rule violates due process, there is no case law supporting the defendant's position. Okay, and they say him. I do believe that this is Bryan Kohberger. It's like, look what I've learned, blah, blah, blah. We're going to go back into 1800 law. Because in law, like when I was in law school, like we had to go right back to the beginning of law, the British North American Act and all this stuff, which is called the BNA Act. We had to go back into all that and learn it all about the trade system and everything they had back there and consequence. And so like he's going right back to the basics of law as it was first established. And it's like things have evolved since the 1800s and early 1900s, Mr. Kohberger. I get what he's doing because I was frustrated. Like I didn't want to hear, not that I didn't want to hear about the BNA Act and all that and how our laws came to be, but some of the laws that are even still on the books today, because they've never come up and never been challenged, but they've also never been used because they're so out there in today's modern society. So I get what he's trying to do, but it's not going to work. A lot of new precedents have been set and rulings that have been set and laws have been changed for reasons that should be easy for any even lay person to understand why certain laws have been changed. Like certain laws that I can take the hides of 4 of your cows for your lack of paying me 2 cents for your 10-pound bag of sugar. You know what I mean? Laws have changed for a reason, Mr. Kohberger. Anyway, let's continue. And like I said, you guys, arguing stuff like this is taking away from your time preparing for your case. You are delaying yourself being able to prepare with all this ludicrous stuff that you are trying to present. I get it. You ain't got it. If they had solid evidence to get their client off, they wouldn't be doing all this. They would be preparing to present their case to prove this all wrong, not how the grand jury came to their decision or anything like that. They would be going, okay, let's go. We're ready. Let's go to court because we've got blah, 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 blah to prove each one of your charges wrong, each one of your theories wrong. They've got nothing. And their best defense is to continue causing unnecessary motions and hearings to just delay. And hopefully maybe something from 1840 law will stick. I don't know. But it's getting old, and I think the judge is getting fed up. Second, an immediate appeal of the orders denying dismissal of the indictment would not materially advance the orderly resolution of the litigation. Quite the opposite is true. Unfortunately, this case has already been pending for a year at this juncture. Trial may not even be set until the spring of 2025. If an appeal is granted now, the case will essentially come to a halt for some period while the appellate court reviews the grand jury proceedings, causing even further delay. And the gain to the defendant, even assuming a permissive appeal is granted by the appellate court and the appellate court rules in the defendant's favor, is de minimis. As the state has stated, charges would be immediately refiled. State differently, the likelihood of the defendant being released from custody, even if the indictment were dismissed by a higher court, is essentially non-existent. The only path forward for either side is trial. Prosecution's getting fed up with having to deal with these frivolous motions. Their attempt to delay. Instead of doing all this crap that you know is going to be denied, start working on getting your case together. And like I previously said, in my opinion, if they had a solid defense case, they wouldn't be pulling all this, hoping something just, please pray, something sticks from the early 1900s. Please say we can still use that. Come on. Miss me with that. Additionally, as time passes, both sides are faced with the reality that witnesses' memories may fade or witnesses may become unavailable. Is that what they're hoping for? Which may cause prejudice to one or both sides. The prosecution is on to them. And this is exactly what I just said earlier, right? Finally, while the court remains steadfast in its obligation to ensure the defendant's constitutional rights are protected, the court is also mindful of the victim's family's constitutional right to a timely disposition of this case. Idaho Constitution, an appeal now would not advance the defendant's rights or the rights of the victim's families. Case law also instructs this court to consider the impact of immediate appeal upon the parties, the effect of the delay of the proceedings in the district court pending the appeal, the likelihood or possibility of a second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. As outlined above, the impact of an appeal now on the parties would not be favorable to either side, and the effect of further delay of these proceedings may result in prejudice to one or both parties. And I think it's going to be more prejudice towards the prosecution. Anything can happen to a witness, you guys. God willing, like, please keep everybody safe. But things happen. People can be in accidents. Their memories could fade. Anything can happen to these witnesses. This is why they want to get it to court quickly. The house has already been demolished. The biggest piece of evidence out there. There's things that could happen that could really screw with this case, especially when it comes to witnesses. Finally, if the defendant is convicted by a trial jury, and especially if the death penalty is imposed, there will be undoubtedly be years of appeals to come where the issues raised by the defendant may now be reviewed by a higher court. Okay? So it's been denied. Okay? Next. So this is a motion to allow certain experts and investigators protected access to view the IGG material. So here is another motion they have filed now. Basically, this is only 2 pages, but comes now, Bryan C. Kohberger, by and through his attorneys, and hereby moves for this court for an order allowing certain experts and investigators protected access to view the IGG materials. Right now, the only people that can view those records are Bryan Kohberger's lawyers, the prosecution, and the judge. Nobody else is allowed to see these records. So now they want to expand that. In part, I do agree with this, but there's parts that I don't agree with. Counsel for Mr. Kohberger has reviewed the materials currently available under the court's sealed order for disclosure of IGG information and protective order filed with the court on 12/29/2023 and requests the court to include additional members of the defense team access to the materials. Mr. Kohberger specifically requests the current protective order to expand and allow defense experts Dr. Lee Larkin, Vicka Barlow, and Stephen Mercer access to the materials. Further, Mr. Kohberger requests that the criminal investigators that are part of the defense team be allowed to have access to the materials as well. That's where I disagree. No. And to be as broad as they are being on this, requests that criminal investigators that are part of the defense team be allowed to have access to, they're not naming who it is. They're not naming why they need it. The investigators, the only reason, in my opinion, investigators would need access to that information is so they can go and hound those people. And this is what the prosecution was trying to stop right at the beginning. That's why they didn't want to give this information. And even though the defense has limited information, there must be something in there that they have seen that they think that they can go hog wild on, like people that they didn't know of before, family members that are no part of this, people that are no part of this investigation. This would open the door for those investigators to go knocking on their doors and try and interrogate them. look into their backgrounds and splash their information all over the place? No, they have no reason to. I agree with the IGG experts that they had in one of their motions that was heard by the court when they wanted the IGG information, and they had the 3 IGG experts. I agree with allowing them to see it so they can advise them on what exactly all this information means, the information that they did receive. But for then the investigators on your team to be able to see that information, no, absolutely not. And I do not think a lot of other people are saying, and I've been sent information that there's even been a couple of lawyers that have said, okay, well, you know, if it's done properly, yeah, let them do it. No, I'm saying no, 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 no. We're going to have to wait and see what the judge decides. But my opinion right now, I'm saying the judge should, in all fairness, exclude the criminal investigators from seeing all this IGG information. The IGG experts that they have on their team should be able to explain and make them understand everything they need to know about the IGG information. They don't need the investigators to also be able to look over this information. Absolutely not. Expanding the current protective order to include additional members of the defense team and experts. Oh, they even want to expand the current protective order to include additional members of the defense team and experts, includes each additional person subject to the restrictions in the protection order. No, you haven't even said. They could hand this to me tomorrow and say, hey, Willow, can you investigate this? They haven't named anybody, number one. And I do believe that the judge is going to deny any of the criminal investigators any access to this material. Now, there is a letter that was sent out, that the FBI sent out, saying this is how we determined that this person was Bryan Kohberger. You know, and I'm sure in that letter, we can't see it because it's all under seal, but I'm sure the FBI said, we submitted it. We got a lead. We got the father, which led us to the garbage, which led us to taking that, which led us to knowing that it was a male offspring of Mr. Kohberger. And we arrested Bryan Kohberger because of the car and all the GPSs and all that stuff that we've got already. And when we did the buccal swab on Mr. Kohberger, it matched. It was a perfect match. Okay, because this is the DNA that was taken from the knife sheath. That's what I think that they had given them. And that's all that they gave them. Right? Now, any other IGG information that was released, I know it was very minimal, is still under a protective order also. And it would probably include a lot of people's names that don't need to be dragged into this at all. So I do believe that the judge is going to give the okay and then be under the gag and restriction and protective order for the 3 IGG experts that testified already in court. I believe that he will give access to them. But as far as the criminal investigators, I said it here first, absolutely not. That's what I think the judge is going to order. Just my opinion. We'll see what happens come court day. So this is the objection to defendant's motion to change venue and request for a scheduling order. Now, like I said, back when we had looked over this motion to change venue, I told you I'm going in order that they were filed. So this was the next filing where the prosecution has put in their objection to the defendant's motion to change the venue and request for scheduling. Now, like I said, the prosecution's getting fed up at these delay tactics. Okay? They're getting fed up. So comes now, and this is 3 pages, you guys, comes now, State of Idaho, by and through, Latah County prosecuting attorney, and objects to the defendant's motion to change venue as it is premature. Oh, well, it's true. The state requests that this court set a trial date. Oh, they are still pushing. When was this filed? February 8th. They want the trial date set. Good show. So the state is requesting that this court set a trial date, a briefing schedule for the defendant's motion, a hearing date for the motion to be heard, and a deadline for supporting memoranda, affidavits, and witness disclosures sufficiently in advance of the hearing so that the parties can adequately prepare. Defendant's motion to change venue is premature and without sufficient basis. Exactly. And that's what I was saying, you guys. Defendant has not provided the court with adequate information to conclude that Latah County jury could not fairly and impartially decide the defendant's case. Well, that's basically what I said. They're saying that they haven't provided adequate information. And that's what I think that they're getting to, is what I said earlier about they haven't done any surveys or gone out in the community to see if they could possibly get a jury or anything like that. They haven't submitted, they're saying they haven't provided the court with adequate information to conclude that Latah County jury could not fairly and impartially decide the defendant's case. Okay, in Idaho, I haven't read through these last four. I just got today, so I haven't read through these ones yet. Hopefully they're not very long. Okay, so defense motion to change venue is premature and without sufficient basis. Defendant is not okay. In Idaho, a motion for change of venue is within the discretion of the trial court. Idaho's appellate courts look to several factors while determining whether a trial court exercises discretion in deciding a motion to change venue, including affidavits indicating prejudice or an absence of prejudice in the community. Yeah, well, that's what I was saying. Like going out into the community, they just worded it different here, I guess. Testimony of the jurors at voir dire as to whether they have formed an opinion of the defendant's guilt or innocent based upon adverse pretrial publicity. Right. And that's what I said, at voir dire. So when you start bringing in jurors and, say you bring in the first 100 jurors and none of them can be fair and impartial, then you've got a problem. You know what I mean? But if you have out of that 100, you have even 15 or 20 that say, no, I've made up my mind, you still have 80 more in that first jury pool that could be potential jurors that could move on to the next phase. And that's when they question them, right? So they haven't done any of this yet. That's what's done at voir dire, is to see if you were acceptable to become a juror. What you know about it, can you be fair and impartial? Do you know anybody in this case? Do you know anybody from any of the victims' families? Do you know anybody from the prosecution or the defense or the judge? Maybe they do. So maybe they lose another 20. So now you still got 60 out of that first 100, right? I believe that they can get a jury pool, but that's just my opinion. But none of that has been done yet. So I see where they're saying that this is premature. Other factors for consideration are whether a defendant challenged for cause any individual jurors, the nature of the pretrial publicity about the case, and the duration of time between the publicity and the trial itself. The Idaho Supreme Court has also explained that publicity by itself does not require a change of venue. Because publicity is not a standalone reason for a court to change venue, this court should decline to decide defendant's motion until a trial date is set and the court has heard adequate facts to enable the court to make a determination. The state respectfully requests that this court set a trial date, set a hearing date for the defendant's motion to change venue, issues deadlines and supporting memoranda and affidavits, and set a deadline for witness disclosures. There you go. They want this to get going. So now, Bryan Kohberger filing yet another motion saying they want clarification of the sealed order for disclosure of the IGG information and protection order. Because what happened was I got these out of the line here. The state objected to the defense motion to change venue, scheduling order. Okay, I clicked the wrong one. It should have been over here. Where is it? Is it this one? Okay, yes. This one shouldn't be there. I doubled up on them and totally missed this one because when the defense filed their motion to be able to give this IGG information to not only their experts, but on IGG, but to their criminal investigators, no. And the state has made, is this it? Yes, okay. So the state's responded to the defendant's motion to allow certain experts. And basically in here, they basically said the same thing, I think, that they said previously. Let me just see. It comes out of state. I don't want to keep repeating stuff over and over, you guys. So I am scrolling through this. This is 4 pages. I'm going to scroll through it. I want to get to the meat of this and see what they're saying. Okay, regarding the expansion of the protective order to include unnamed criminal investigators, that's what I said, unnamed criminal investigators, unfettered access to the IGG materials, the state objects. At a minimum, individuals who will have access to any IGG materials should be named. Further, defense is filed to make an adequate showing as to why such individuals need the information for the preparation of the defense. Defense states that the information is requested to investigate how and when Mr. Kohberger was identified as a suspect. This information can be, I thought they already gave that. Let me just see here. This information can be obtained. Okay, yes, here it is here. This information can be obtained from the 2-sheet letter from the FBI to the state dated November 28, 2023. The state objects to the balance of the IGG materials being provided to the criminal investigators for the reason articulated by the court in its protective order. Okay, so then they made a request, a motion. That's the one that we just seen here. Okay, so then they said that they wanted clarification regarding the sealed order. The court sealed order states that no individual on the family tree may be contacted by the defense or any agent. So remember what I said, you guys? They wanted to start contacting people that are in his family tree. That's a no-no. It does not pertain to this case. Okay? And they're saying the court sealed order states no individual on the family tree may contact by the defense or any agent of the defense without prior authorization from the court after showing as to why such contact is necessary and material to the preparation of the defense. Right. People on that family tree are not going to have anything to do or whatever with this except for the father. Right. How they got to the father's DNA and then the father. I can see that. Anything more? It's off limits. Oh. So what they're saying here is anything that the investigators need to know, they can refer to the letter from the FBI to the state dated November 28, 2023. State objects to the balance of the IGG materials being provided to the criminal investigators for the reasons articulated by the court in its protective order. And that is to protect all these other people that are on there that didn't ask to be involved in this and that are no part of this. The defense experts or investigators should not be allowed to use the protective materials to identify individuals or witnesses to contact without prior authorization from the court and after showing why such contact is necessary for the preparation of the defense. This would not prohibit the defense from contacting potential witnesses learned through sources outside of the protected information, which means if they happen to come across, say, Bryan Kohberger's sister, and they got information from somebody that Bryan Kohberger's sister may have information as to what Bryan Kohberger did when he got home. That's how they found out about Bryan Kohberger's sister. They could go and investigate her, subpoena her, all kinds of stuff like that, because she put it out there or somebody came to the defense. I'm trying to explain this the best I can. So if they found an aunt that maybe Bryan Kohberger stopped at between leaving Washington and getting to his parents' home, and he gave that aunt some information that could be of some evidentiary value in this case regarding the case, and they found that aunt through some other means, they can go and talk to that aunt. So say somebody says it came out maybe by his father or a friend, or somebody said, hey, well, he stopped at his aunt's place on the way from Washington to Pennsylvania, and she told me that he told her a few things about this case that he shouldn't know, stuff like that. Well, they already know of that aunt, and they're going to want to talk to that aunt, which is completely okay. But if you only learn about this aunt and that she lives in between Washington and Pennsylvania, and you only find out about her through the IGG information, that's off limits, whether she has information or not. You can't use this IGG to go searching for other people that may hold information that you want. You get what I mean? If it was found out through another source already, you can use it. But if it's only found out through the IGG, then you can't use it. And that's what the judge was trying, or the prosecution was trying to protect. Like, what if there's like 10 family members that live in Washington? Those family members are going to be open to reporters and YouTubers that goes banging on people's doors, and investigators for the defense. And this, they're going to all go banging on these people's doors. No. Or what if they find out that there's somebody in between Washington and Pennsylvania that they could have stopped at? No. Unless they have found it out from another source, it can't be used. You can't find a connection to Bryan Kohberger, like one of his family members, in the IGG, and then go in and interrogate and harass that person, or dox them, or harass them. No. So I do agree with, that's why these investigators, the investigators only need this information for one purpose: to investigate those people who are not a part of this case. So the state respectively submits that the appropriate course of action would be for the court to amend the sealed order for disclosure of the IGG information and protective order to allow Dr. Leah Larkin, Vicka Barlow, and Stephen Mercer access to the IGG materials disclosed to the defense. The criminal investigator seeking access to the information should be named in the order, and those investigators should only be allowed access to the November 28, 2023 letter provided to the defense. The state also requests, and that's the letter from the FBI, they don't want them having this IGG information that was turned over to the defense. The state also requests the following language for an amended order. So this is the amended order. They want this included in that order, and that the doctors and that and the IGG experts that were already called to testify can see the information, but they're not allowed to disseminate it. They'd be under that gag order, right? And that the investigators may view the November 28th, 2023 letter contained within the materials. Any further dissemination of the materials or the information contained within the materials must first be approved by the courts. And I agree with that. The only letter that they should be able to see is the one that the FBI gave. This is what we did. This is how we found Mr. Kohberger, and found that the DNA sample that we had was a male offspring of Mr. Kohberger's. And that's how we came to learn about Bryan. Started following Bryan, picking up garbage, blah, 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 and nailed him. Okay, with the GPS, with all this other information that they have. And I guarantee you they've got tons more. Tons more. Okay, they wouldn't have gone for the death penalty if they didn't have a rock solid case, even though we may not agree with that right now, having a rock solid case, because we have not seen all the information. And just because Ann Taylor says something doesn't make it true. She can say whatever she wants to try and sway public opinion, which I think she's done. Like, there's no connection here to Bryan Kohberger. We found several, even little YouTubers like us, that are questionable, really questionable. Parties that Kohberger attended that the girls could have been at. Kaylee being at a bar just down the street from Kohberger's apartment, and it was a bar that the students from Washington State, that was their bar. Could he have gone there and seen them? Like, there's other instances too. I don't want to get into things that I haven't been able to fully verify yet, but they do seem promising. And if I can figure that stuff out, I'm sure the prosecution has. They're a million times smarter than I. So if there's little tidbits that I'm catching in some of these documents, I guarantee you the prosecution has rock solid on it. I just can't verify it 100%. I can verify it 80, can't verify it 100 because I can't see the documents are sealed. So I can't go back through the documents to see, okay, wait a minute. This was just mentioned. Why is that being mentioned now? That it was a slip somewhere. Why is that being mentioned? I want to go back in the documents and find where that was mentioned before. I can't do that because they're all under seal. So if I have caught on to a few things, guarantee you the prosecution has it. And if the prosecution has that, like, that's a game changer. And I believe they do have it. They just try and cover it up a little bit with the slip of the tongue that they made, but I caught it. And like I said, working in this field for over 30 years, now retired, I used to go through court documents for criminal cases every single day. When I first started working at the criminal law firm that I was in, that's what I had to do. I had to go over court transcripts, sit downs that we've had with our client, and then witness statements and find discrepancies, or where you said one thing here and now you're saying this here. I did that for probably the first 3 years of my career. And it was like monotonous, but that's where I learned how to catch little things. And now I understand why those lawyers that I was their underling, okay, they're paralegal for, why they put me through that. Because if I missed something, I was held accountable. Because in a court case, you mess up one line could screw your whole case. You miss one little piece, it could screw your whole case. So now I understand it. And the years going forward after that, the next 25 years, that was always on my mind. Read it once, read it twice, read it 3 times if you have to, and then go back into the other documents and make sure this is the same and catch the discrepancies. And for 25 years, 26 years, I did that. And I thanked them for putting me through that, although I didn't like it at the time. So that's what's going on here. And I wanted to see this trial because I think a lot of the naysayers right now are going to have their jaws hitting the floor. And like I said, I'm not going to say 100% until trial. I'm at 80 right now that he's guilty. There's still 20% that he's not. Right? I'm not at 100% yet. But I want this trial, guys. Let's go. Okay, so that's what we got for the Kohberger. Now, as far as the Chad Daybell case, let's get rid of some of this. Okay, Chad Daybell case. Not much going on here. Let me just see here. Since the hearing, where Chad's lawyer tried to withdraw from the case, there's only been a couple filings. There's been some supplemental discovery disclosure. Let me just see what this is. I think it's just them asking for discovery, and that's just to keep the record up to date. Documents and tangible evidence, yes. This is signed by Lindsay Blake. Hang on, let me just see this for a minute. Oh, they're not going to show it to us. Okay, so there's been some more stuff, I guess, that has come in that they are handing over. Let me just bring that over here. And let me see this one. Oh, I know what this is. Okay. Okay, so let's get to this first. Oh, I thought there was something else. It's like, oh my God, is there more evidence that they found? But no, it's not. We'll go over it. It's going to be really quick. A sip of my coffee. Okay, so this one here. Oh, I'm an idiot, you guys. Here we go. Here we go. So this here is by, and this doesn't surprise me in the least, John Pryor has filed a motion to extend time for the expert disclosure and reports. Comes down defendant John Pryor and moves defendant John Pryor. See, this is what I don't like, you guys, when mistakes like this are made. This should be saying, comes now defendant Chad Daybell buying through his attorney, but it doesn't. It says defendant John Pryor. John Pryor is not a defendant. Sorry, you guys. Things like this just irk me. Should be defendant Chad Daybell buying through his attorney, John Pryor, but it doesn't. Moves the court for an order extending the time for the defendant to disclose experts and expert opinions. The court set a deadline for disclosure of expert and expert opinions for January 31st. When was this filed? He filed this the day before everything was supposed to be filed. See this up here? He filed this on the 30th of January. Everything was due by the 31st. Wow. Okay, the court set a deadline for the disclosure of experts and experts' opinions for January 31st, 2024. The court set a deadline. So everything was supposed to be in by the next day, and he files this the day before. That the defense has provided our team's experts the discovery provided by the states in preparation of the upcoming trial and tomorrow's deadline. At approximately 11:40 a.m. on January 30th, the state provided notice to the defense that it is supplementing their discovery response with additional evidence. This in itself is not the concern, as the state has an obligation to timely continue to supplement the discovery responses. However, this evidence at the time of this pleading has not been provided to the defense. That the state provided a listing on the amendment of the evidence is advised that the evidence would be overnighted to counsel by tomorrow. The defense has not viewed the evidence and in all likelihood would not be able to view the evidence in time to comply with the court's order of tomorrow's submission of experts and their respective reports. The evidence, at least in part, is scientific in nature, and in other instances seems to be reports from June of last year. Disclosure of evidence a day before expert deadline is, in the very least, questionable as to timing. So they're saying that they just got, they were just handed reports on evidence that they've had since last June. I don't believe that. The fact that the disclosure, at least in note parts, it is in scientific in nature, concerns the defense that the state's disclosure creates a situation in which the defense experts have created their opinions and have not been afforded access to all the evidence in the possession of the state. The defense requests the court set an expedited hearing to address the motion to extend in time. In addition, the defense may ask the court to either exclude the evidence or again seek other continuance of the trial to afford our expert to have a fair opportunity to review. Now, I don't know what this is, you guys, but if you remember, the reason why, let's go back to January of last year. If you remember the defense saying, there's more things that we want to test, right? We want to test this stuff. So we're not going to be ready to go for trial. We're going to have to sever these cases. And we're not going to be ready, blah, 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 blah. It's going to take us months and months and months to do our own testing on this evidence. And I believe that this was DNA off of something in the tool shed at Chad Daybell's. This was their way of vacating the trial, because the trial was going to start, vacating the trial and severing the cases. Because now the prosecution was putting Lori Vallow's trial at risk for a constitutional right to a speedy trial that she never waived. Okay. So they had to get her to trial. So they severed the cases and they said, okay, Mr. Pryor, we're going to vacate the trial date and give you time to have your experts go over this info. And then they didn't do it. Right. So I don't know if there was something with that stuff that the prosecution did again, whatever. And then I don't know. But that's what I think that this is implying. Well, just because you didn't follow through and then we were requested to do other testing or whatever because you wanted to do that, I don't know. But I think it all stems back to that. Because next filed is this. Comes now the state of Idaho, and this was filed on the 30th. 7th supplemental discovery disclosure, because they're saying they didn't get this disclosure, right? So the state of Idaho, by and through Fremont County, blah, 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 notifies the defendant of the following: documents and tangible objects. Defense counsel can inspect and copy or photograph the items or material described in Idaho Criminal Rules 16b by simply making prior arrangements with the Madison County Prosecutor's Office or the law enforcement agency holding such items or evidence. In addition to the above, the state may also utilize the following as evidence at the trial, all of which has either previously been provided. And I do believe that it was previously provided. Remember when he said, well, I can't find this. And this was like a fight back in June. So back in June, when he brought this up, he says, well, I can't find it I've got terabytes and paperwork. And so the prosecution then said, well, if you want to see that and you can't find it, come into our office, make an appointment, come on in, and we will show you it in our files. We will show you it and send it to you again, which they did. And he says, I still can't find it. Or they told him where he could find it on which disc, whatever, and he says he still couldn't find it. I think it's all bullshit. But this is all stuff that was previously provided to John Pryor. And like he said at the last, when he was trying to get thrown off this case, I just don't have time to get ready for this trial now. I just don't, there's tons of stuff I got to go through. Well, you should have been doing that for the last couple of years, shouldn't you have? You should have hired more people if you couldn't do it on your own, right? But no, you wanted all of Chad Daybell's money to yourself. And now that Chad Daybell has no more money, because you own his house now and property, you own every little bit of money that would have been left from Tammy Daybell's life insurance, any money that Chad Daybell ever had, you now have, and it's gone. He's now indigent. Now that you got every red cent and bled everything dry, now you want the state to pay for you to bring some other people on. Isn't that ironic? Why wouldn't they have hired these people prior? Why didn't you do this a year ago, John Pryor, 2 years ago? When you seen the amount of evidence that was coming in, why didn't you hire somebody back then? No, because then you would have had to share that money. And even in his hearing that he had when he wanted to quit, deuces, out of here, no more money. I should be being paid. You got, how much was that property? Somebody looked into it and it was like $600,000 they could get for Chad Daybell's house and property, plus all the cash money he got from Chad Daybell. You've been paid almost what? Well, you still own the house, which has probably gone up in value by now. So you've got almost $500,000 already in property and in cash. That's why you, won off the case now? Well, okay, well, I will still continue on this case. Yeah, you got $500,000 worth of assets from them. And none of these victims can ever go after Chad Daybell for anything because he has nothing left, and John Pryor made sure of that. He signed over his house and property to John Pryor. That was his payment. Every dime that he had was given to John Pryor. There's nothing for these people to ever come back and sue him civilly once this is done. There's nothing to take anymore. It's gone. It's been given to John Pryor as payment for his defense. But these are all delay tactics because you didn't hire appropriate amount of people for your team, knowing how in depth this case was going to be. But you sat day in, day out at Lori Vallow's trial. Why weren't you preparing for your own defense and had an underling go and take notes? Or you could have listened to it all at a later date. An underling could have listened to the recordings of it at a later date and taken any exculpatory maybe evidence from that you could use in your trial. Why did you do it, John Pryor, when you could have been preparing for your trial? So I find that, anyway, let's get going. We're going to trial April 1st, but this is another attempt to try and get that trial date vacated. It's not going to happen. I think the prosecution and the judge sees through him. You asked for this. Your defendant asked for this. Your client asked for this. We're going. So, and then there's an 18th one for the same thing. And the district attorney, the prosecution has said the same thing. So there's attachments that they put in both of these. See this? See attachment A11 and over here A10. They're showing them, this is where we gave it to you. Just because you couldn't find it, don't say we didn't give it to you. And this happens a lot. But anyway, that's what I got for you guys for these two cases. Chad Daybell is going to court. Trial starts April 1st. Also in Chad Daybell's case, Rachel Smith, one of the special prosecutors, has as of February 28th, she's no longer going to be on this case. She is moving on to other things. That was the special prosecutor that was appointed by the district attorney, I guess, to the prosecutors to help with this case. She is leaving as of February 28th, so we won't be seeing her in court. Bryan Kohberger has a hearing. I've written it down, February 28th, 4 p.m. Eastern, where they're going to be going over these motions. Chad Daybell has a hearing coming up on the 22nd. I'm sure that they are going to be going over anything that has come up between his last hearing and the 22nd. It's a pretrial conference, and we will be able to watch that. And that is on the 22nd. And I believe it's at 11 a.m. Eastern. I'll have to look that up, but you will see it on the thumbnail. I will put the thumbnail up the day before, and you will see that. But I will be live streaming that one, and I will be live streaming the Bryan Kohberger hearing on February 28th. So with that, I'm going to end this like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surrounding. I love you guys to the moon and back. Bye-bye for now.